Welcome, everybody. It's the day we've all been anticipating. Zellner has responded. I'm here joined by Travis, Big Jeff, Kelly, Reality Check, and Just a Denny. Jeff made some slides for us to go through, so we'll start with those.
Just a couple to start us off. I mean, I've read the brief in anticipation of this, and this is my interpretation of the brief. And we have Travis with us, and the good news about having the lawyers with us is that if we have anything to interpret, we can ask them. Of course, the bad news is at the end of it, despite my exuberance, lawyers always manage to extract their cause, right, Travis? I mean, when you win a lawsuit for $100,000, what do the lawyers do? They take 30 of it, right? So at the end of the
more like 40 plus costs.
Yeah. So at the end of the day, Travis is here to boil down my exuberance to say what it really says. But I'm really excited about the brief. And I thought it would be a good thing to at least talk about a couple of things up front. That way, when we get to them in the middle of the brief, people are will understand a little bit better what it means. And I thought there'd be no better way to do that than a little game of Jeopardy. Anybody got the music for us? I guess not. So, all right, let's go on to the first category. And there's only one category. We're not going to spend forever doing this. How about we scroll up one, Justin? One more slide. All right. Oh, so we saw Kathleen had a tweet today, right? Yep. The Avery reply brief has been filed. We'll post it on our website as soon as possible. Her version of as soon as possible and ours was a lot different. I think a lot of people were like chomping their fingernails off. We're going to win this. So that's a pretty bold statement, right? I don't know that she's ever been that bold before. And I do notice that she must have been, her battery must have been dying, because that does not say at Big Jeff or at Millbilly on that line. So I think that's because her phone was dying. What do you think? What do you think about that, Millbilly?
Nah. I'd rather stay.
So let's play some Jeopardy. Okay, whose words that start with E? How about you get it in the screen? There we go. That's the answer to this one. Okay, but when you submit something electronically, what's it called? Everyone knows because he put up the answer in e-file. Let's go on to the next one. Scroll up in one slide, Justin, for us. Oh, that's 2 slides. This is not working well at all.
All right.
Well, okay. Well, we do need to get to one of these. So if you could scroll to the slide that has the complicated word on it. The question for that slide read, if I can scroll to it on mine because I can tell you what it said. What legal term does Kathleen Zellner use to tell Josh Call, Judge Ashat, Fallon, and Sweaty Boy to take their procedural bar and ram it up their collective asses? Travis, can you take that one for us?
Estoppel.
Can you explain to us what that means? I think that's probably a word. I'd rather not. She uses it and then gets into it. I think maybe if you explain what it is up front, that will help people as we go through the brief understand what she's done. To me, what it means is you can't say it's this thing in one case and then that thing in another. So but that's as much as I can understand. So maybe you can help us out.
Well, estoppel just means to stop, and then in the legal context, there are many different types of estoppel, but basically it's equitable, meaning that a court looks at the equities of a situation and says, the law may say For example, procedurally, you're supposed to do A, B, C, D. But because of the equities, the fairness of the situation, we're going to stop you from trying to use that as a defense. And that's the context that's being used here. The states argued at length, ad nauseum, whatever you want to say, about procedural bar because, again, Stephen had a pro se 97406 motion that was dismissed and a new one filed. And the state saying, well, the statute says you got to bring everything in one motion. And Zellner is saying, well, wait, we had an agreement. And so you are estopped from using that defense of the procedural statute. The equities are, we had an agreement, everyone knew we had an agreement, we were proceeding under that agreement, and it's just not fair for the court to allow the state to proceed with that inequitable situation. That's what estoppel is in this case.
Yeah, so maybe we can highlight that a little bit better when we get to when she talks about the merits, and you can help point out exactly where the state is different, is trying to be different in one place and the other. I think that would be helpful as we read. There's a couple places that I was really confused, and I'm glad you're here to help us out. But I'm going to begin the read right. Oh, but before we go, two more words that start with E: evidentiary hearing and exoneration. So those are the two that I wanted to get in there before the thing, but we failed miserably at the PowerPoint. But I'm going to start reading. In the state of Wisconsin Court of Appeals, District JJ, I think that is, State of Wisconsin versus Stephen Avery, on appeal from the orders denying post-conviction relief and additional scientific testing entered in the Circuit Court of Manitowoc County, long case number. The Honorable Asshat W. Sukowitz, presiding judge, replied brief of...
It should say the dishonorable Angela
Sukowitz. Oh, okay. The dishonorable Asshat Sukowitz. See, my Boston accent is really coming through, Billy. I don't know if you guys can make it out what I'm actually trying to say, but reply brief of defendant appellant Stephen Avery, Kathleen Zellner with her partner Stephen G. Richards, attorneys for the defendant appellant. The table of contents, introduction, page 1. Argument starts at page 4. The state is estopped from bringing procedural bar claims, and that's what we're going to talk about when we get to it. Section 2, the state's erroneous application of the fundamental principles of post-conviction review, otherwise titled, "This is my house, bitch." Section 3, Mr. Avery's claims are not procedurally barred. Section 4, the circuit court erroneously exercised its discretion in denying Mr. Avery's motion to vacate and motion for reconsideration in contradiction of the 2007 order by Judge Willis. Number 5, the state mischaracterizes Mr. Avery's argument regarding trial defense counsel's ineffectiveness. Section 6, Mr. Avery's Brady and Youngblood claims are not barred because they were raised in supplemental motions. Section 7, because Mr. Avery's factual allegations must be assumed as true, he is entitled to an evidentiary hearing. And the last section will be the conclusion. And I can't wait to hear, Travis, how we have to assume things are true. Maybe we save that for when she brings it up. And I'm going to scroll way past all of these references to the introduction, which starts on the PDF, page 7. And I think we're a little delayed, so I'm assuming we're going to get there, Millbilly. Introduction.
Yep.
Stephen Avery, who we'll call Mr. Avery for the rest of this brief. You note that the state didn't call him Mr. Avery, but left that at Avery, has spent 5,343 days, or 128,232 hours behind bars for his second wrongful conviction. He has endured the mental anguish of knowing that he is innocent and his constitutional rights to a fair trial are violated. The state, in a desperate effort to keep Mr. Avery in prison, devotes 104 pages to arguing that Mr. Avery's claims are procedurally barred. However, the state ignores the most important undisputed fact that refutes its entire argument that Mr. Avery is procedurally barred from bringing his new claims. There was an agreement on September 18th, 2017, between the state and Mr. Avery that Mr. Avery could amend his June 2017 974.06 motion without opposition from the state, perform additional scientific testing, and schedule a 4-week evidentiary hearing if needed. And that's a reference to that. Proof of the agreement is evidenced by the undisputed fact that the state did not object to Mr. Avery's October 6, 2017 motion to vacate the October 3rd, 2017 court order dismissing his June 2017 974.06 motion. The circuit court also recognized that the state and Mr. Avery had made an agreement as described above. Because of the undisputed agreement between Mr. Avery and the state that he could amend his June 2017 974.06 motion, all the state's current arguments about Mr. Avery being procedurally barred are waived, and the state should be stopped from raising the procedural bar arguments. The circuit courts are replete with legal errors. Judge Assat doesn't know her ass from the hole in the ground, in other words. As the state points out in the state's brief, pages 17, 20, 102, 103, 104, 108. The state had to correct her that many times. Because of its legal errors, the circuit court failed to address many of the issues Mr. Avery raised. So there is no record for those, for this court to determine whether the circuit court erroneously exercised its discretion. In fact, it is an erroneous exercise of discretion to fail to exercise discretion over multiple issues. Alternatively, if this court engages with the state's arguments, Mr. Avery presents sufficient reasons as to why his claims are not procedurally barred, including the 2 supplements to his June 2017 974.06 motion allowed by this court, which conclusively defeat the state's claim that successive and not supplemental motions were filed. Additionally, Mr. Avery presents Brady and Youngblood claims discovered after his June 2017 974.06 motion and new evidence which are not procedurally barred. At the trial, the state's primary witness, Bobby Dassey, who we'll call Bobby from here on in, committed perjury when he testified that Ms. Hallback never left the Avery property and that he was asleep when he was doing internet searches. Right? We have the records of the internet searches, so we know that. He has a direct connection to the murder by his subsequent admissions, violent pornography, and word searches that reflect knowledge of the crime and the victim, motive and opportunity to commit the crime, and plant evidence against Mr. Avery, including bones from his burn barrel and blood from Mr. Avery's sink. Trial defense counsel failed to hire the necessary experts and failed to investigate and establish third-party suspects pursuant to State versus Denny. Most importantly, the state's primary witness, Bobby. Prior post-conviction counsel was ineffective in all these same ways. Current post-conviction counsel has uncovered numerous Brady and Youngblood violations, the cumulative effect of which undermines confidence in the verdict, as per Kyle versus Whitney, which we mentioned in Avery's brief, pages 39 through 49. The state's brief fundamentally misunderstands the basic facts of the case, the law of the case, effect of the supplements that this court has allowed, the effect of the circuit court's legal errors, and the estoppel effect of the 2017 agreement between Mr. Avery and the state. And I'm going to read this, that this is footnoted. I'm going to read the footnote right now that talks about the agreement. The state argues that Mr. Avery relies upon the incorrect standard of review for a trial court's ruling, state's brief, page 1, by using the term abuse of discretion. Wisconsin's change from abuse of discretion to erroneous exercise of discretion language is a distinction without a difference. As the court stated, we are not changing the standard of review, just the locution, or just the words. Brookfield versus Milwaukee Metropolitan Sewage District. So she's giving a little stab back for that thing that they gave her in that brief. Okay, now her argument, and probably will stop maybe right after this for Travis to give, or at a convenient point. Travis, you tell me when it's a good point to interrupt, to get into a better definition of this estopped, because I don't think that's a word or a legal thing that people are familiar with. I know that I certainly wasn't. So Roman numeral 1, the state is estopped from bringing procedural bar claims. In Wisconsin, the doctrine of judicial estoppel is used to prevent litigants from playing fast and loose with the judicial system by maintaining inconsistent positions during litigation. Salveson versus Douglas County, 2001. Specifically, judicial estoppel precludes a party from asserting a position in a legal proceeding and subsequently asserting an inconsistent position. Contrary to the state's argument that it does not matter what the parties agreed to, state's brief, page 73, I assume that's the page number, the state's prior agreement with Mr. Avery's counsel utterly disqualifies the state's procedural bar arguments, which is the focus of the state's brief. The state's brief is estopped from entirely changing its position and arguing that Mr. Avery is procedurally barred from raising his claims after it agreed that Mr. Avery could amend his motion, conduct additional scientific testing, and if needed, schedule a 4-week evidentiary hearing. Judicial estoppel applies to the parties' positions, not that of the judge, according to a case labeled State versus McFarland. And I guess according to another state case, versus Johnson. I mean, that might be a good place, Travis, for you to jump in. There seems to me they're saying that it's not really up to the judge to change this because the state had agreed. The judge is not an arm of the state. The judge is supposed to be independent. The state agreed to do the testing. And now they're saying, and these other things, and now the state is saying that he's procedurally barred from bringing this stuff up and modification after the state had already agreed to it. So that seems to me what it says. Is that really what it says?
Yeah, you all, you specifically and others paraphrased that, but last time we were together when going through the state's response, there were comments like, well, how can the state take the position X at one particular period of time? I think the way it came up was, how is it that for a year they were going along with doing more testing, item FL, looking at other things, cooperating with that, and then all of a sudden after the judge issues an order saying, no, it's procedurally barred because you filed a second 97406 motion, how can the state be allowed to all of a sudden switch positions? And this is just the legal way, the way the case law sets out exactly what instinctively you and others were saying. How can the state be allowed to proceed to agree to testing and do all these other different things? And then when they get a favorable ruling out of the blue, all of a sudden switch course. But no, it means exactly what you described, that instead of looking at the bare bone requirements of the procedural rules, it's an equitable argument, meaning fairness, and that the parties entered into these agreements and not only entered into them, but acted on them. And then here's another phrase that's going to pop up at some point, but Zellner detrimentally relied upon the state's representations and agreements. Specifically, that do we need to let the court know by filing a stipulation and order? And as she's pointed out, and it's uncontroverted, she's pointed out that Fallon said, no, we don't need to do that. I'll let the court know after I hear back from Calumet County or Manitowoc County, whoever had the RAV, on scheduling the inspection of the RAV. So no, you're exactly right. It's just how the case law has described what you need to show an agreement between litigants to rise to the level that it will prevent a party from asserting a defense that they would have. Clearly, without these facts, filing a second 97406 motion is very problematic, and it's very dangerous for the defendant who's doing that. You have one shot at it, one and only one shot, or you've got to have extremely good reasons. And she's showing with this estoppel argument, this is why we proceeded the way we did. And it's uncontroverted. One thing I was asked before we went live, was I surprised about anything? Actually, I guess I am surprised a little bit. I'm surprised she's not stronger in that. They had an opportunity way back when she filed the motion to vacate the judge's order, which came out of left field. And they could have filed, although they didn't need to oppose the motion, they certainly could have clarified and said, yes, while it's true, we do not oppose the motion to vacate, we do want to clarify the agreement wasn't as strong as what she's claiming, that there were discussions about this, but no agreement. Nothing. The affidavit of Zellner, and it was not only her, but her law partner that went down and met with those attorneys. And they said all of these specific things were agreed to, and that there were discussions about other things that were going to be agreed to. So I'm surprised she's not stronger about that. You just read the part, that she read that, they didn't oppose it. I would have added, not only didn't they oppose it, they didn't clarify it, they didn't correct it. The only evidence before the court on appeal is Zellner's version of that agreement. But I don't know, maybe people think, or after hearing what you've read or reading it on their own, believe it's strong enough. But I probably would have added another sentence or two that they've had multiple opportunities to correct that, but did not.
And not to mention, she had 97 words left to use. So, yeah.
I didn't count them. Yeah. It almost seems like a tactic that she didn't bring it up in the first one, that she left it and they didn't touch it, and then she's bringing it up in the response that they don't have an opportunity to reply to, right? That they don't get another chance. That this is the last one before they go off and reconsider for the next 14 months or whatever.
Well, that's a very astute observation, Jeff, because that's a delicate balance. You can only reply to what the state puts in their response. You can't bring in an extraneous matter. And so if you go back and look at her original brief, she puts enough of that in there that I think you're right, that she made it so that the state had no choice but to discuss it at some point, which they did, which leaves the door wide open for her to come back very, very strong. And so some may be asking, well, why is she allowed to bring up this estoppel argument if it wasn't brought up in the state response? And she's allowed to bring it up because she doesn't know what their position is until she sees their response. She lays it out clearly enough in her appellate brief to where they had the opportunity to either say, no, the facts are contrary, the record doesn't support this agreement is claimed, et cetera, et cetera. They lay out what their response is. It's all procedural bar. It's the state's problem for not addressing. Both sides have to anticipate. Zellner has to anticipate, and she did, what the state's response was going to be, which was procedural bar. And we talked about that last time. The state is required to anticipate, and they did throughout their brief, what the reply is going to be. But everyone plays by those rules. Appellant files a brief.
Yep.
Respondent files an opposition or response, as they call it in Wisconsin, and the appellant gets to file a reply. So, there is gamemanship and strategy to it, but she laid out enough clearly that they had the opportunity to address the estoppel argument, chose not to.
Yeah, that word wasn't even used in her last brief. It just seems to me she kind of, this was her sort of ace in the hole, and I started looking it up as soon as I saw what it meant, and I was like, oh, this is good. This is good stuff. Hey, maybe I should continue reading. We'll never. Thank you, Travis. Okay, so I'm going to continue the read. A reviewing court determines de novo. I think that's probably as if they were looking at it for the first time. Whether the elements of judicial estoppel apply to the facts of the case, according to a Salveston case. 3 elements are required for a court to invoke the doctrine of judicial estoppel. The first is that the later position that they took must be clearly inconsistent with the earlier position. The second element is that the facts at issue should be the same in both cases. And the third element is that the party to be estopped must have convinced the first court to adopt its position. And in fact, Mr. Avery meets all 3 elements for the following reason. He meets the first element because the state's current position that Mr. Avery is procedurally barred is clearly inconsistent with the state's September 18th, 2017 agreement with Mr. Avery that he could amend his petition, which is interesting because I remember the state must have said 50 times in the original brief that we don't know why Kathleen Zellner filed early. That was her decision to file early. But it appears that the state, and I think I was wondering, why'd she do that? Why'd she do that? But it appears she had a tacit agreement with the state that it was okay to update the brief with the evidence that she might have found during the testing. So, according to this agreement, they can't bring up a procedural bar. That's the way that I read this. The second element is that which said the facts should be the same. She's arguing, well, the facts are clearly the same before this court and the circuit court. And the third one, which was that the party to be stopped must have convinced the first court to adopt its position. She counters with her element 3 that shows that he's eligible for this by saying the state, by not objecting to the existence of the agreement described in Mr. Avery's motion to vacate, convinced the circuit court that there was in fact an agreement. So she's saying that agreement was established. And now she's going to talk about the state failed to object to Mr. Avery's motion to vacate. And as Travis said, they didn't do anything. They didn't object. They didn't try and clarify it. They just completely ignored it. But Zellner writes, the state had the opportunity to object and failed to do so when Mr. Avery submitted his 974-06 motion to vacate on October 6, 2017, which described the agreement for amending his motion, conducting additional scientific testing, and scheduling a 4-week evidentiary hearing if necessary. In his motion for relief from judgment, Mr. Avery specifically pled on October 6, 2017, current post-conviction defense counsel spoke to the prosecutors and informed them that this motion would be filed today to vacate the order. This motion has been presented to and reviewed by the prosecutors, and the prosecutors agree to the factual accuracy of the representations regarding the content of the September 18, 2017 meeting made in this motion. So she said it right there in black and white in her motion, and that, yeah, they saw it and they agreed to it. And now she continues outside of that inset. When the current post-conviction counsel asked whether the circuit court should immediately be informed of the agreement, Prosecutor Fallon, otherwise known as Emperor Palpatine, stated that once he had finalized the scheduling of the RAV4 examination with law enforcement, a stipulated order could be presented to the circuit court, similar to the original stipulated order for independent scientific testing entered on November 23, 2016. Mr. Avery relied upon the agreement with the state and the state's request for additional time to schedule the testing of the RAV4. And she footnote 2, and I'm going to read footnote 2 before continuing. Vitally important evidence must be tested with more sensitive DNA testing, including the following. The blood stain, A23, we all know what A23 is.
Sure do.
Dr. Silverman has some excellent presentations on A23, a blood stain in the back of the RAV, from which DNA testing by Sherry Colhane eliminates Avery, Stephen, and Brendan from that. On the rear cargo door, and 8 latent prints found on the RAV4, both of which exclude Mr. Avery. Unidentified male DNA on the license plate, Wisconsin State Crime Lab items AJ and AK. Potential DNA in the battery cables, hood latch, and interior hood release, and lug wrench. I didn't know about the lug wrench.
Yep.
The suspected human pelvic bones, and any other DNA testing of the interior and exterior of the RAV4 that could produce new evidence of a third-party suspect. So that was her footnote to that. I'm going to continue on with the main paragraph. By not objecting to Mr. Avery's motion to vacate, the state has waived this argument on appeal. The state should be stopped from changing its position now. Mr. Avery relied upon the state's representations that it agreed to allow him to amend his motion, conduct new scientific testing, and schedule a 4-week evidentiary hearing if needed. And she cites a case called Mowers versus City of St. Francis. So yeah, I think that's pretty much exactly what you said, Travis, that the state said one thing and now they're trying to claim another. Do you have a quick comment on that?
Nothing to add to what we discussed immediately before this break. That's what she's laid out is, there was a definite agreement. Again, I would have argued it maybe a little bit stronger, but I think that's clear for everybody, whether they have legal training or not, that there was a deal and there's this factual background to it, and that I think it leaves the state in a kind of the position they were in back when they were trying to oppose the motion for a remand for the Youngblood preservation issue, and these same attorneys came up with that specious argument about, well, she can dismiss her appeal and then test bones and then file a new appeal. And the judge in granting the remand said they thought it was disingenuous, silly for the state to make that kind of an argument. So here we see that they've laid out all of the form, the procedural requirements the state's laid out, and for 2/3 of their brief or more, honed in on this one aspect of 97406, the subparagraph that says, all claims shall be brought in one motion. And yet they don't even address it. Because they can't. They never opposed it, so they spend all of their time on that and don't even address the fact that Zellner and her partner had worked out an agreement that clearly contrary to the position that they're taking now. But it's
well, it surprised me.
Those requirements are met. So the issue.
What surprised me? Oh, go ahead, Travis. Sorry.
So it's what's the problematic part of this? Well, there's no clear cases and there's no clear statutes where you have a conflict. So what trumps? The agreement between the parties or a circuit court judge's ability to control their docket, their schedule? So honestly, frankly,
that's the question I was going to ask, actually, because I have this opinion that or this unfounded legal misconception that judges can do whatever the F they want. And what she seems to be claiming through citation of this, I can't remember which one it was. It's that it's up to the parties and not the court. And she did have a citation, and I obviously don't not familiar with that case, as I'm not familiar with most cases.
Yeah, and I haven't read that, but there's no case that says, at least in the last 25 years, that attorneys can tell a judge what to do in terms of scheduling or what. But there are cases that say if the parties have agreed to a course of conduct and the court makes some order or some ruling unaware of the agreement or the context, that is unfair, and the court should undo its order or decision not knowing about the agreement between the parties. Here's just an easy example. Most states, if you're served with a civil lawsuit, either called a petition in state court or a complaint in federal court, you typically have 30 days to respond. Frequently, attorneys agree with each other to give another 30-day extension. You typically always follow that up, if you're the defendant, with a letter saying this is to confirm our conversation where you graciously granted me a 30-day extension to answer, otherwise plead, in the case of Smith v. Jones. I've probably dictated that letter 1,000 times. You always confirm that, but there are lawyers that you don't have to do that. There are lawyers that if you somehow forgot, they'd call you up and say, hey, I gave you a 30-day extension and we're a week past, what's the deal? But there's a newer generation where you got to dot every I and cross every T, or sometimes big cities, they're little more no quarter given than smaller towns. It's like everything else, because it's a smaller community and you're going to run into those lawyers frequently in small areas. But clearly,
what about if you're
Zellner
desperate
does
to bury
not want to be in this position. Clearly, Zellner would have rather have sent a letter on her own saying we're in the middle of this and just copied Fallon on it. Because you never expect that this is going to happen. And so there's no clear law on it. And so what the judges are going to be looking at is one of two things. They're either going to be looking at, hey, this just isn't fair. And so let's restore the parties to the position they were in before the court's order came out. And so they would order the testing is going to go forward as agreed, and the parties can agree to amend the motion for post-conviction relief. Now, she's not specific on that. She's always been vague or general. So that's probably, that term, a draft pick to be named later.
Yeah.
They will probably discuss that in general. We know that she was agreeing to dismiss two claims, the prosecutorial misconduct claim and the brain fingerprinting, which ultimately were dropped from her appeal. And I suspect because she didn't want the state to be able to come back and say, well, there wasn't an agreement, you breached the agreement. You went ahead and went forward with these two claims you said you were going to drop. So,
right.
So some judges are going to look at that and say, well, that's just not fair. Others, and when we get to the right point, I've done a bunch of research about how long I think it's going to take them to decide, and just let me know when you want to get to that. But some of the judges are former circuit court judges, and trial court judges, they come from all different ends of the philosophical spectrum, but they all have one thing in common. They generally like to run their court the way they like to run their court. And so some of those judges on the 3-judge panel may have some sympathy for that. The bottom line, what I'm trying to convey is that it's not clear cut, and it's no position that a post-conviction lawyer would want to be in on purpose, but it's the realities of the situation. And I think she's done an excellent job of laying out the equities that weigh in favor of restoring the parties to where they were in August of, what year are we talking?
2017. Yep. 17.
Yeah.
Yeah, and part of that, it also seemed, was that Fallon also said, if you want, you have a 4-week evidentiary hearing. So it seems like if you're going to restore to that state, you're going to restore to the precipice of an evidentiary hearing that he seems to have acknowledged as inevitable.
Mm-hmm.
Well, that's an excellent point. So, again, just real briefly, she mentions that all throughout the thing. Down at the motion to vacate, in her appellate brief, and not only that, it was going to take 4 weeks. No court gives you, okay, I'm going to give you the month of July to do your evidentiary hearing. They knew they were going to get a few days here and a few days there. They said they even had scheduling. Hey, Dad. They even had scheduling worked out that they were going to start in January, and they anticipated it would take through spring. That's in her brief. That's in her motion. It's in her affidavit, and there's nothing to controvert that. And that prompted you and others to say, how on earth can the state, in its response, take this position that they're procedurally barred when they just had this meeting where they not only discussed additional testing, but when they wanted to do the evidentiary hearing. So that infers they all acknowledged that evidentiary hearings were going to be necessary, that they didn't want to start until the beginning of the year in January, that they figured it was going to take 20 full judicial days, which is 4 weeks, and that would require the scheduling be spread out from January until the spring. And so she's laid out legally what the requirements are, and that the equities weigh in her favor. And so you don't write briefs to apprise the court of both sides. You write a brief to advocate your client's position. The state really screwed up. They had an opportunity to anticipate and address it. They chose not to. Now this is just hanging out there with no response. So that is definitely point Zellner, but it's still going to come down to, there are no clear-cut cases, there are no clear-cut rules. It's going to come down to whether the judges give more emphasis to fundamental fairness. I know everybody's got their opinions on Wisconsin justice in general, but fundamental fairness versus the ability of a trial court to determine their calendar and how they're going to run their court. That's basically what it comes down to.
Can you give me a sound check, Millbilly? Am I still
Yeah, I hear you.
coming through okay? Am I good?
Yep.
Tari?
You're good. Nope.
2, which is the state's erroneous application of the fundamental principles of post-conviction review. Coming from the lawyer that's exonerated more people than anybody else in the whole country, this one should have been titled, "This is my house, bitch." The pleading standard. The state argues that Mr. Avery must affirmatively allege that his facts were sufficiently pled. That's according to the state's brief, page 42, which is not the actual standard. Now who's taken who to law school? The proper standard is from State versus Allen in 2004, which Mr. Avery satisfied in his brief, even presenting a chart for greater clarity, which he put on pages 99 to 103. And we're going to talk about the standard governing a petitioner's right to an evidentiary hearing. The state argues 13 times that Mr. Avery failed to prove his facts and disprove the state's case. See the state's brief, pages 4, 18, 32, 33, 39, 44, 54, 55, 64, 66, 69, and 106 and 107. However, see the state's brief, page 23, conceding that an evidentiary hearing is a forum to prove factually supported claims. Excuse me. The standard is that the facts must be assumed to be true in determining whether to grant an evidentiary hearing, and that's according to State versus Bentley. And I can't wait to hear why that's true, Travis.
But I'll continue to interrupt you right here.
Oh, yeah, please. Yeah.
So that's critically important. And if we could scroll back up just a quarter page, that page before. So the standard is, and this is a question on everybody's mind that talks about the appeal. I hope she gets an evidentiary hearing. She needs to have an evidentiary hearing. So she's laid out, what do you have to show a court to get an evidentiary hearing? Because with this judge, she just could not get an evidentiary hearing. Again, going back to the state attorneys thought she was going to have an evidentiary hearing. They were in the process of scheduling 4 weeks of an evidentiary hearing. It was going to take from January until spring. So you don't have to, although she has affidavits and things of that nature, but let's just go to the return of the bones and an evidentiary hearing on the return of the bones. So you just lay out enough facts to show we're entitled to a hearing. You're not required to prove your case. You're not required to prove that your client is actually innocent. Otherwise, no one would ever get an evidentiary hearing, and no one would ever get a new trial. You have to show that you have more than just speculation, more than just a theory, more than, it's fine for all of us that are, armchair detective, theorize and do those kinds of things. But in a court of law, the standard is higher. It's, you've got to get an affidavit from a credible expert. She's got 4 or 5 of those. You got to have proof evidence that things like biological evidence were disposed of improperly. She's got the own sheriff's office records showing that and detailing who was there and when. But you need an evidentiary hearing about who were they returned to? Do they still exist? Were they buried? Are they sitting on a mantle somewhere?
Yeah, so the
Go ahead.
Yep.
So
Is it just Jeff or is it me?
No, it's him.
Okay.
it's him. Okay, I'm gonna continue the read until he comes back. Then
You bet. All right.
You're here. I got you.
Okay. Oh, okay. Oh, yeah. So I guess the question that you might have faded out on was when they specifically say that you have to assume the facts are true. Are you talking about? They're talking about the facts that are provided by the experts, and they don't necessarily have to show relevance.
Well, the way she phrases it is a little bit confusing. So let's say she says the facts are true, the bones are returned. You can't just put a bare allegation, a bare statement. I think Bobby did it. You have to come up with admissible evidence, which she did, the affidavit of an expert, the identification and the introduction of records regarding computer searches. And so you have to have supported allegations. But if you have supportable allegations, which she does, you have to assume that they're true for purposes of determining whether.
I think he's a guitar again.
I hear him.
Can everybody hear me, or is it?
I think
you hear him? Okay.
So it's got to be more than a bare allegation. But once you come forward with admissible, credible evidence like affidavits or documents, if you have supported allegations, those have to be assumed to be true for purposes of determining whether to grant an evidentiary hearing. Now, at the time of the evidentiary hearing,
I see.
Then all bets are off. She's got to put the expert on the stand. The state, if they want to, can bring back Eisenberg or whoever else they're going to get. She'll put on her DNA expert if that's one of the issues. But so she makes it she simplifies it a little bit. But if that is true, if you come forward with a supported allegation, the court needs to treat it as true. What the state did, and what she's pointing out, is they're making the type of argument you would make at the conclusion of an evidentiary hearing, which is totally improper. All she has to do, and what she did, is lay out, hey, I'm not just blowing in the wind. I'm not just speculating. This isn't a hunch. This is credible, respected experts who have verified certain things in combination with other evidence, which shows that either the attorneys were deficient for not hiring the experts like I hired, or there was material evidence that was concealed or not provided to the defense in violation of Brady, or that there was biological evidence that was improperly disposed of, contrary to state statute and or Youngblood. And I should get an evidentiary hearing on those items. And in two of those things, the CD or DVD, I can't remember which, but the computer information
the on CD, the
Brady claim,
the CD,
that was remand number one, and the court said the appellate court judge is trying to clue in the district court, saying, we're sending this back to you to conduct whatever proceedings are necessary to ascertain the facts on whether this is Brady or not. And the judge just concludes, I've seen enough. This can't even qualify as Brady. And then the same thing happened on the bones, the destruction of the bones. Remand number two, and the court used that same language, saying, and the circuit court, the trial court, is authorized to conduct any and all proceedings to determine the facts. And unfortunately, she just felt that she read that, I guess, as an invitation just to deny it. But
right. She already knew what the facts were. She didn't need to find them. So with that's great. So why don't I continue with the reading based on what you just said? I think that's an excellent clarification. If we can continue.
Yep.
So I'll start a little bit above where you are, Billy, but you can leave it there. The standard is that the facts must be assumed to be true in determining whether to grant an evidentiary hearing. State versus Bentley. The state fails to assume Mr. Avery's facts are true as the standard requires. The state reverts to a sufficiently proven standard which does not even exist. And that goes to footnote 3, which is at the bottom of that page. And I'm going to read that footnote. The state relies on cases where the court conducted an evidentiary hearing, for example, State versus Carter. So, continuing on, Mr. Avery is not required to prove the facts supporting his claims before this court. The state's brief inadvertently concedes the need for a hearing by creating numerous factual disputes and arguing and weighing the evidence. See factual dispute chart. Ironically, the state uses the term conclusory 25 times in a conclusory fashion to describe Mr. Avery's arguments without explaining what is conclusory about them. And there's a quote, a post-conviction movement need only provide sufficient objective factual assertions to be entitled to an evidentiary hearing. That is, a movement need not demonstrate theories of admissibility for every factual assertion he or she seeks to introduce. According to a decision by Love in 2005 and State versus Balliet in 2011. And that's the one. So yeah, I mean, I think Travis, with your with the explanation you had, I think that should be pretty crystal clear to people what that meant. So I'm going to move on to Roman numeral 3. Mr. Avery is not procedurally barred by his 2013 pro se 974-06 motion. The state argues Mr. Avery failed to show sufficient reasons for not raising his June 2017 claims in his 2013 pro se motion, arguing that Mr. Avery's indigence and lack of legal training were not sufficient reasons. State's brief, page 11. The state's brief claims Avery's assertions that he was incapable of recognizing and raising legal claims was demonstrably false. The circuit court remarked that Avery's pro se motion recognized sufficient legal issues which the court previously ruled on. State's brief, page 14. However, the circuit court's recent opinion is disingenuous because the circuit court previously ruled that Mr. Avery's claims in his pro se motion were unestablished, empty and without substance, completely meritless, and bordering on frivolous and wildly speculative. And that's according to one of Judge Assad's previous rulings. Miraculously, the state has transformed Mr. Avery into a legal scholar to serve its own purposes. Mr. Avery has demonstrated sufficient reason throughout his brief and supporting affidavits. Affidavits are considered part of the legal pleading, according to the Love 2005 ruling, where the Wisconsin Supreme Court found that an affidavit was not insufficient to make a valid claim for newly discovered evidence, reasoning that a movement need not demonstrate the admissibility of the facts asserted in the post-conviction motion, but rather must show sufficient objective material, factual assertions that, if true, would warrant the movement to relief. The state misinterprets Avery's argument to conclude that Mr. Avery's claims were available to him since 2013. In 2013, Mr. Avery lacked legal knowledge, had cognitive deficiencies, had no way of knowing the factual and legal basis of the claims in the instant appeal. Mr. Avery's 2013 pro se motion demonstrates this, as none of his 11 issues were meritorious, or could have possibly raised the subsequently discovered Brady, Youngblood, new evidence, or ineffective assistance of counsel arguments. He had no way of acquiring knowledge of the factual or legal basis for his current claims. The state concedes that Mr. Avery's pursuit of his pro se motion was diligent, but he failed despite his diligence. The fact Mr. Avery in 2013 was diligent despite the unavailability of necessary information supports his position. See Williams versus Taylor. And I quote, where the Supreme Court found that the habeas petitioner was entitled to an evidentiary hearing on a juror bias claim since he was diligent in his efforts to develop the facts. Because Williams was not on notice of the juror bias issue, the Supreme Court found that Williams did not fail in his duty of due diligence. The Supreme Court held that unless there is a lack of diligence or some greater fault attributable to the prisoner or the prisoner's counsel, a failure to develop the factual basis of a claim is not established. Applying Williams, Mr. Avery did not fail to assert his claims of which he had no notice. Further, as in Williams, Mr. Avery's claims were unavailable to him, even if he did have legal knowledge, because they are based on evidence withheld by Brady and Youngblood violations, discoverable by only expert examination, and not pursued or recognized by his prior attorneys. Because Mr. Avery is a learning disabled indigent prisoner, he simply could not have been aware of the factual basis of his claims. The Wisconsin Supreme Court has also found sufficient reason where the movement lacks factual awareness of the claim, State versus Allen in 2010. Even if Mr. Avery knew he needed experts, he could not persuade any experts to assist him. Therefore, he could not have known that the blood had been selectively planted in the RAV4. The bullet fragment, FL, had wood, not bone, embedded in it. The hood latch swab never swabbed the hood latch. Miss Hallback's subkey could not have fallen from the bookcase, and the subsequent discovery of numerous Brady and Youngblood violations. Avery's brief, pages 39 to 49. Mr. Avery wrote dozens of attorneys, all of whom rejected his request, including me, after his direct appeal was denied. Mr. Avery also wrote to laboratories that would not respond unless he had an attorney. So every brief, pages 16 to 17. Mr. Avery described the impossibility of his efforts to get experts due to his pro se status, not the lack of awareness that he needed them, right? So he knew he needed them, but just couldn't get them. The circuit court should have granted an evidentiary hearing on Mr. Avery's allegation that he lacked the factual basis in 2013 to make the current claims. Significantly, the state ignores State versus Anderson in 2013. Which Mr. Avery relied upon in his June 2017 974-06 motion. In Anderson, the defendant, like Mr. Avery, argued that his cognitive deficiencies provided a sufficient reason for not raising certain claims prior to his 976.04 motion. The court was skeptical of Anderson's claims regarding his disability but the court assumed Anderson's disabilities excused his failure to raise the claims earlier. For example, applying Anderson. Mr. Avery is not barred from raising his claims because he raised several sufficient reasons, including his cognitive deficiencies and possibility of hiring experts and lack of factual and legal awareness, for explaining why he could not raise his claims in this 2013 motion. Onto a new subheading. The circuit court failed to rule on prior post-conviction counsel's ineffectiveness. So we had a lot to unpack in that previous one, Travis. It just seems that she makes the argument that because of his pro se motion, that according to these other legal standards, he should be allowed to pursue, again, trying to debunk the procedural bar claim that they had because he had filed these in the 2013 motion. What do you think on a scale of 1 to 10?
Well, I think
being,
what she's trying to do there is just point out a circular argument, that they just keep going in a big circle. And she anticipated it, Unfortunately, this is a problem that there's this procedural bar. Normally, you just don't even have to deal with that, but it happens. She came into the case when there was a pro se 97406 motion, and it got dismissed. And that leaves open the state. The state's not going to argue, a big fat defense that's sitting in their lap. They're just not going to say, oh, no, we don't want to take advantage.
Right.
But which is why this estoppel argument is so kick-ass, because no appellate court would say, they're not going to look at these arguments about, he's indigent, he's in prison, he's, has mental deficits. They have not been sympathetic to people in prison bringing multiple post-conviction motions. But now she's got this narrative that's uncontested that, it's not that, Your Honors. What it is we all agreed this is how we were going to proceed. And now they're taking this contrary position. So this stuff, you'll remember, when we talked about this before on this very channel, that, I said I was concerned that there is a second
procedural bar
97406 motion, because that puts the burden on Zellner to show, instead of just filing it and not having to show anything, you just proceed forward. But as soon as you dismiss one and file a second one, now you're in the position of showing this is why I did this, and these are the cases that say I'm allowed to do that. And when there's gray area in that state, you don't want to be in that position. But so I think Roman numeral 1 and 2, and you always start out, remember, with your strongest argument first, and you always end on a strong one, and we'll see what her last one is. But this stuff about, I think she shifted it outside of, he's shown why you do this, that. Now, on the post-conviction appellate counsel and a night hearing, she's absolutely right on that. She's just re-pointing that out. And she's saying, I'm not attacking prior appellate counsel. Yeah, you do need a night hearing for that. I'm attacking, or I'm criticizing, or I'm bringing a legal complaint on behalf of Stephen, that post-conviction counsel, which isn't covered under night, and it's clear, and she just repeats the language right there, clear as day, just one more time. And this just gets all complicated. The reason why she's complaining about post-conviction counsel is trying to hook in arguments that would otherwise be waived, like hiring expert again. And
right.
Because of the trappings of the court and this form over substance and this things like EDPA and post-conviction reform across the country, they put all of these bars in place that if the defendant has a legitimate post-conviction issue that he discovers, he's required to be clairvoyant, all-knowing, be able to read minds, because you really need to bring it all at once, because otherwise, if you discover something other than smoking gun DNA, you discover something legitimate, like that a CD or a DVD was withheld from you, that biological evidence was returned. The state has multiple procedural arguments they can make against you that don't even get to the merits of, hey,
right.
This person very likely perjured himself on the stand, and that could have made a huge difference with the jury. That there is scientific evidence out there that shows if this bullet went through skull, as I think most reasonable people agree was argued by the state in opening and closing, that couldn't have happened to a reasonable degree of scientific certainty.
Right.
And so people get so frustrated, and I understand it. It's like, well, we've got all of this stuff over here that really needs to be looked at by a court, but yet we've got all of these hurdles that we're making you jump through before we'll even look at this stuff. And it's, I don't know if any of y'all saw the movie Tucker, about a guy invents a great automobile, and he's in federal court, and he's in a criminal case for fraud, saying he collected money from investors and he had no intentions of building 50 cars. And he ends up taking over his defense at the end, and they work out the kinks, and they drive the 50 cars down to the federal court in Washington, D.C. And he's, Your Honor, the cars are all outside. Just let the jury look. I'm sorry, the evidence is closed. And fortunately, justice prevailed in that case, and he won because it's Hollywood. But this is the real world, and it's frustrating and confusing for people. And unfortunately, Stukowitz done herself a huge disservice for people outside that county, people within Wisconsin and certainly outside of Wisconsin. The way she's gone about this, if she could have held the evidentiary hearing and just said, well, yeah, that expert was extremely impressive, and the fact finding is totally up to her. It can't be disturbed on appeal. There could be 49 witnesses that come in and say the light was red. And if one comes in and says light was green, if she finds that the light was green, there's no appellate court in the country that will disturb that.
Wow.
And so I don't know if she's dumb or lazy, or people have said both, but she's the most, by a large margin, I heard, per capita. You have the right to disqualify a judge there, one automatic one, and she's the most paper judge in Wisconsin. And, there's typically a reason for that. At least where I practice, judges who get papered all the time, there's for sure definite reasons for that. And so, it's unfortunate because now no matter what happens and she gets her evidentiary hearing, if it's in that court, I mean, God, no one's going to assume that justice is going to be at the deal. But continue on. I don't know if that answered your question. And then when you get to a point, I need about 5 or 10 minutes
very much so.
To tell people whenever you think it's appropriate. I did research on what the next steps are going to be. So whether we get through everything tonight or whatnot, but whenever we're at a good stopping point, I can let people know what the next steps are and about how long it's going to take.
All right.
Yeah, people need to know. I think we're pressing. So back to the title of this subsection. The circuit court failed to rule on prior post-conviction counsel's ineffectiveness. The circuit court failed to address prior post-conviction counsel's ineffectiveness because it applied the wrong legal standard. The circuit court stated, quote, "A circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel, State versus Knight. In this matter, if the defendant wishes to pursue claims regarding his appellate counsel, the defense may file a Knight motion with the Court of Appeals. Wisconsin law requires a defendant present a claim of ineffective assistance of post-conviction counsel to the trial court in the first instance. See State ex rel Rothring versus McCartry. A Knight petition is only appropriate for claims of ineffective assistance by appellate counsel. See Jackson versus Bainan. Because Mr. Avery alleges ineffective assistance of post-conviction counsel, not appellate counsel, the circuit court improperly refused to rule on his claim. The state acknowledges that the circuit court was wrong about the law on post-conviction procedure because it confused the procedure for raising ineffective assistance of post-conviction counsel with the procedure for raising ineffective assistance of appellate counsel when rejecting the claim. State's brief, page 17 and 20. However, the state argues that if the trial court reaches the proper result for the wrong reason, it will be affirmed, citing State versus Holt. Holt is distinguishable from this case. Holt involved the trial court's decision to deny a jury instruction. The appellate court found that the trial court's refusal to give the instruction was proper, even though the trial court's reasoning was incorrect. Unlike Holt, where the record was sufficient to resolve the issue, in Mr. Avery's case, there is no underlying record or discretionary decision to review because the circuit court failed to rule on the issue. Because the circuit court applied the wrong standard and believed that the appellate court had to address the ineffectiveness of prior post-conviction counsel, it did not evaluate the substance of the claim nor create a record for this court's review. Stated differently, the record lacks any discretionary decision for this court to review. According to Leiter versus Labuchenko, in Leiter, the appellate court remanded an issue for an evidentiary hearing because the circuit court failed to make a discretionary decision, so there was no record or decision for the appellate court to review. In Mr. Avery's case, in addition to failing to create a record for this court to review, the circuit court abused its discretion by refusing to rule on his ineffective assistance claim. The failure to exercise discretion is an abuse of discretion, according to McCleary versus the state. In State versus Kenzie, when faced with a similar legal error by the trial court that resulted in no record for appellate review, the court held, if the circuit court is able to conduct an adequate retrospective hearing, it shall do so. Therefore, in the instant case, the court must hold an evidentiary hearing about the allegations of the prior post-conviction counsel's ineffectiveness. Next heading. Mr. Avery pled sufficient reasons for failing to raise prior post-conviction counsel's ineffectiveness in his pro se motion. The state argues Mr. Avery fails to establish a sufficient reason for not including his current ineffective assistance of prior post-conviction counsel claim in his pro se direct appeal. Mr. Avery not only alleged a reason, he has demonstrated a sufficient reason consistent with the Wisconsin Statute 97406 and State versus Escalona. What constitutes a sufficient reason pursuant to Wisconsin State Statute 97604 is determined on a case-by-case basis. The Wisconsin Supreme Court has held that ineffective assistance of post-conviction counsel may constitute a sufficient reason. State versus Romero-Georgiana. See also State ex rel Rothring versus McCartry. That's a hard name to pronounce. Mr. Avery's pleading.
That's pretty good guess. But so again, but she's making this argument. You know, if the court rules against her on the estoppel argument, then it's like, okay, if not A, then B, and B was your procedurally barred. But then she argues, well, wait a minute. The court didn't even rule on my argument about post-conviction counsel. And so she's trying to get at least one issue. She's not going to put all her eggs in one basket, even though Roman numeral 1 is pretty strong. That's all I wanted to point out there.
Yeah. Okay. Yeah, that's a good point. I mean, she's kind of taking them to school the same way they attempted to take her to school. You know, you didn't even rule on the right thing, jackass. The next subheading, Mr. Avery's pleading alleged sufficient facts for his claim of prior post-conviction counsel's ineffectiveness. Mr. Avery alleged sufficient facts about prior post-conviction counsel's ineffective failure to hire experts, conduct a significant investigation, or review discovery regarding potential third-party Denny suspects to warrant an evidentiary hearing. Clearly, prior post-conviction counsel recognized the need for experts on Mr. Avery's behalf because they asked the court for an extension to retain experts, stating, counsel would be remiss if they did not consult with scientific experts on matters beyond their own knowledge and expertise, just as counsel would fail to satisfy their ethical obligations if they did not pursue potential leads for post-conviction relief. Emphasis added. Despite recognizing the need, prior post-conviction counsel did not retain any experts. I mean, that was to talk about Hagopian and that, right? The pivotal question is whether Mr. Avery's 97406 motion is sufficient to entitle him to an evidentiary hearing where he would have the opportunity to show that his trial and prior post-conviction attorneys rendered ineffective assistance of counsel. Balliet. Determining whether the counsel's performance was deficient requires the court to focus on counsel's perspective at the time of the trial or post-conviction, according to State versus Foy. This determination often cannot be made without counsel's testimony, without which a court cannot focus on counsel's perspective and cannot otherwise determine whether the counsel's actions were the result of incompetence or deliberate trial strategies, according to Foy. Additionally, in State versus Curtis, the court held that assuming there are factual allegations which, if found true, might warrant a finding of ineffective assistance of counsel, an evidentiary hearing is a prerequisite to appellate review of an ineffective assistance of counsel issue. This court must assume, as true, trial defense counsel Strang's affidavit that Strang and Buting were ineffective and that they failed to hire ballistics, trace, and blood experts. The court must also assume that the trial defense counsel were ineffective in failing to investigate and impeach the state's primary witness, Bobby, at trial as evidenced by their investigator's affidavit. Additionally, trial defense counsel was ineffective in numerous other ways. And she cites the pages in her brief where she articulates that. So I'm going to move on to Roman numeral 4, unless there's any objections.
Nope.
The circuit court erroneously exercised its discretion in denying Mr. Avery's motion to vacate and motion for reconsideration in contradiction of the 2007 order by Judge Willis. And her first subheading here is Mr. Avery properly argued that the state's refusal to vacate its judgment violated the 2007 preservation and testing order. The state incorrectly asserts that Mr. Avery failed to raise the argument regarding the circuit court's violation of the 2007 preservation and testing order, claiming, and she quotes, "This argument appeared in none of Avery's motions to the circuit court. See 629, 631, 632, 633, 635, and 636 in the state's briefing." So they definitely piled it on, definitely. However, it did. In his second amended supplement to his motion for reconsideration, Mr. Avery pled, "The effect of the court's failure to vacate its October 3rd, 2017 ruling is that it has unilaterally blocked all future scientific testing in the Avery case in direct contravention of the April 4th, 2007 order entered by Judge Willis." The state cites, oh boy, Shonchek versus Picard in 2003. Shonchek is an apostate, and it is not, as it is not a post-conviction case. Rather, it's a products liability case in which a defendant manufacturer failed to mention even once that the plaintiff violated a Wisconsin statute until his appeal. Next subheading, Mr. Avery's newly discovered evidence in his motion for reconsideration. The state disputes Mr. Avery's evidence is newly discovered, citing State versus Fosnow, 2001, to argue that newly discovered evidence does not include new appreciation of the importance of evidence previously known but not used. In Fosnow, the defendant's new diagnosis was merely the new interpretation of existing evidence. Similarly, in Vara, the evidence was newly discovered importance of evidence previously known and not used, where both trial defense counsel and the defendant knew of the defendant's head injury, which could have supported an insanity defense. Both cases are in apostate because Mr. Avery's newly discovered evidence does not consist of already known facts. Rather, post-trial experts revealed facts that were unavailable at the trial. In denying Mr. Avery's motion, the circuit court erroneously applied the newly discovered evidence standard to mean that the test could not be available at the time of the defendant's previous motion, pursuant to Wisconsin Statute 97406 or any of the other appeals or motions filed after trial. The circuit court believed that the new evidence could not have existed before 2017. That is not the standard. When moving for a new trial based on newly discovered evidence, a defendant must prove four things. The first is that the evidence was discovered after conviction. Second, the defendant was not negligent in seeking the evidence. Third, the evidence is material to an issue in the case. And four, the evidence is not merely cumulative. And this is all according to State versus McCollum in 1997. If the defendant can prove all four of these criteria, then it must be determined whether a reasonable probability exists that the jury, that had the jury heard the evidence, it would have had a reasonable doubt as to the defendant's guilt, according to Love in 2005. Here, Mr. Avery presented the following new evidence. Dr. Christopher Polenic, using a 2016 state-of-the-art microscope, examined item FL and the hood latch swab, and his findings have produced new evidence that is totally inconsistent with the state's theory that Ms. Hallback was shot in the head while lying on Mr. Avery's garage floor, and that the hood latch swab was actually used to swab a hood latch. Dr. John Dahan, I say that 5 times fast, a forensic fire expert, determined that no body was ever burned in Mr. Avery's burn pit based upon data he collected from his experiments burning human cadavers since 2012. Dr. Carl Reich was available through the use of new source testing, RSID testing, developed after the trial to eliminate blood, semen, and saliva as the sources of DNA from the hood latch swab, and offered the opinion that DNA was consistent with that what would be found on Mr. Avery's groin swab from skin cells. So that's pretty clear that her new evidence, according to her, seems new, and not just the recycling of the old evidence. On to Roman numeral 5. The state mischaracterizes Mr. Avery's argument regarding trial defense counsel's ineffectiveness. The state mischaracterizes Mr. Avery's argument that trial defense counsel was ineffective, stating, in a nutshell, Avery argued in his June 2017 motion that Strang and Buting were ineffective because Avery believes he could have prevailed at trial if Strang and Buting had presented his planted evidence defense in the manner current post-conviction counsel formulated. Mr. Avery never argued that trial defense counsel were ineffective for failing to present his planted evidence defense. Instead, Mr. Avery argues that they were ineffective for failing to hire experts, failing to investigate and impeach Bobby Dassey, failing to establish third-party suspects, and failing in numerous other ways. See Hinton versus Alabama in 2014, where trial counsel was ineffective for failing to hire a competent expert to bolster his trial defense, and that defendant was misidentified as the defendant was misidentified as the killer. State cites Lee versus State in 1974 for the proposition that permitting post-conviction counsel to argue a different game plan after the contest is over would be Monday morning quarterbacking. However, Lee is distinguishable. Lee's defense was available at the time of trial, but his counsel merely chose not to pursue it. Conversely, Mr. Avery is not arguing that his counsel could have chosen a different defense out of those available. Rather, he argues his counsel was ineffective for failing to hire experts or investigate. It sounds to me, Travis, like they were listening to you and Tracy Stuntzy talk about that this is ineffective counsel and not a Brady. It sounds like she's trying to sneak this one in there when she didn't really have it in her other brief. So it's a good thing that she was listening to you guys on the 80 More Things podcast. The state again misstates Mr. Avery's argument by claiming that Mr. Avery is content. Mr. Avery is contending that trial defense counsel should have hired his specific current experts, when Mr. Avery actually argues that trial defense counsel was ineffective for failing to hire experts in these specific areas of expertise: blood spatter, DNA, trace, ballistics, police procedure, forensic fire, and anthropology with Kerf Mark specialization. Mr. Avery never argued that the trial defense counsel should have hired his specific experts. Instead, Mr. Avery argues that trial defense counsel was ineffective for failing to hire experts. Avery's brief, page 65 through 89. Footnote number 4, and that footnote states, the state claims Wisconsin has never found that a police procedure expert is admissible. However, Greg McCrary has been admitted by the, oh my God, she does one of these things, by the 7th Circuit as a police procedure expert in Jimenez versus the city of Chicago. And she cites a couple of cases. So she's saying, F you, that you're wrong about that. So that's I hate it how the footnote scrolls over to the next page. That's the dumbest thing I've ever seen. Yeah. But continuing into the main body, besides this, the state grossly mischaracterizes Mr. Avery's ineffective assistance of counsel argument as being that the quantity testing results were both newly discovered evidence and that Strang and Buting were ineffective for failing to present them. The newly discovered evidence supports Mr. Avery's argument that the trial defense counsel failed to present an expert to establish that law enforcement planted Mr. Avery's DNA on the subkey. The reason trial defense counsel did not discover this evidence was their failure to hire experts, which trial defense counsel admits. Avery's brief, in two different briefs, two different references. Thus, the state cannot, even by misstating Mr. Avery's whole argument, rebut trial defense counsel's ineffectiveness. Roman numeral 6, Mr. Avery's Brady and Youngblood claims are not barred because they were raised in supplemental motions. The state claims that Mr. Avery's motions are successive, one after the other. The state's briefing, page 89. However, per the appellate court's orders, Mr. Avery's motions are supplemental motions. See June 11, 2018, Order 729, and February 27, 2019, Order number 770. The law of the case doctrine is a long-standing rule that a decision on a legal issue by an appellate court establishes the law of the case, which must be followed in all subsequent proceedings in the trial court or on a later appeal. State versus Stewart in 2003. Also citing Univest Corp versus General Split Corp. Even so, the state accuses Mr. Avery of filing in a piecemeal fashion. Filing under the same case number is by nature not piecemeal litigation. See Bannister versus Davis, Director, Texas Department of Criminal Justice Correctional Institutions Division in 2020, where the Supreme Court recently, 2020 sounds pretty recent to me, held that a Rule 59E motion to alter or amend a habeas court's judgment is not a second or successive habeas petition, but rather part of the first full petition. Take that, Mr. Call.
Yeah, so that's her biggest
Mr. Avery's
dig of the
motion,
brief so far is she says, here's a clue, state, that it's not successive motions, that it's supplemental. When you file something under the same case number, that's a clue that it's in the same case and it's supplemental. That previous 97406 motion, that pro se, had a completely different case number. Yeah, so you got me there, but all of these pleadings, whatever they're called, supplemental, reconsideration, they're all successive. And the one on the CD asking to remand, and then the one on the evidence preservation, Youngblood, remand number 2, are clearly successive and, supplemental. And she points out, she argues very strongly and very well here that the state is raising a cloud of dust and complaining they can't see. And she's done it brilliantly there.
Nice. Excellent. So I'll continue. That's great insight, Travis. Thank you. Mr. Avery's motions and supplements were all filed under the same case number and are simply a continuation of the same proceeding. See Gonzalez versus Crosby. Issue preclusion doctrines are inappropriate where the record reflects that the petitioner is diligently pursuing his claims and supporting facts in his first meaningful post-conviction review. See Lochner versus Thomas in 1996. Holding that abuse of the writ doctrines have no applications in a first habeas corpus proceeding, and Williams 429 in 2000, holding that a prisoner who acts diligently to pursue his claims has not failed to preserve his right to a hearing on his claims. So bam. Next subheading, Mr. Avery has sufficiently pled his Youngblood claim. Even though it is undisputed that the state violated the notice requirements of Wisconsin Statute 968.205 on evidence preservation, the state claims that Mr. Avery cannot prove its bad faith and thus makes an insufficient claim under Youngblood. The argument that Mr. Avery alleges a statutory claim overlooks that Mr. Avery only uses the violation of the statute to show the state's bad faith in breaching its duty of notice. Parenthetically, a prosecutor has a duty to preserve potentially useful evidence for trial, according to Arizona versus Youngblood and California versus Trombetta. While the Trombetta and Youngblood evidence preservation doctrines originally applied only when evidence was destroyed pre-trial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable to the post-conviction destruction of evidence in State versus Parker. The state claims that Parker should be overturned after a quick read. However, Parker has been followed and affirmed by numerous decisions and is void of any negative analysis. See State's Brief 108, footnote number 5. And I'm going to read footnote number 5, which says the state incorrectly argues that the district attorney's office for the 3rd Judicial District versus Osborne should control rather than Parker. However, Osborne does not apply because it is a 1983 claim and the petitioner did not attempt to follow the state's procedure. Okay, so back to the main briefing. Therefore, the state's argument is devoid of any rationale for overturning this court's prior decision. Okay, good. Her next subheading, the bone fragments recovered from the gravel pit constitute apparent or potentially exculpatory evidence. the state misconstrues the apparent potential exculpatory nature of the Manitowoc County gravel pit bone fragments. Mr. Avery presented in the affidavit of Dr. DeHaan that Ms. Hallback did not burn in Mr. Avery's burn pit and her bones were planted there. Dr. DeHaan opined that Ms. Hallback was burned in a burn barrel, and it is undisputed that larger human bones were found in the Dassey burn barrel, evidence number 7964. A human scapula, portions of a spinal column, metacarpals, and large bone fragments. The Dassey burn barrel bones had cut marks. The gravel pit bones had cut marks. By destroying the gravel pit bones, the state prevented Dr. Symes, Mr. Avery's expert, from matching the cut marks between the burn barrel and gravel pit, thereby establishing that the Dassey burn barrel was the primary burn site. This is the first time I've heard that. And what about you, Millbilly? I've heard that the gravel pit was the first burn site. This is the first time I think she's asserted that the Dassey burn barrel was the primary burn site.
Well, she's right. He would be able to determine that the marks were made by the same instrument.
Yeah, no, definitely true. And that giving away the bones, but not only precluded the DNA, but examination of that as well, wasn't it? That would help establish that they were the same from the same person. Mm-hmm. But this is all brand new. I don't recall this in any of the last brief at all.
Now we know why Mr. Kratz didn't want to talk about them bones in the quarry.
Yeah, for more than 20 seconds.
And which quarry?
This evidence would
talk.
Yeah, or both. This evidence would establish. Oh, go ahead. You have another comment?
Nope.
I talked over you. Apologies.
Go ahead.
This evidence would establish a direct connection between the Dassey burn barrel, the mutilation of Miss Hallback, and the subsequent planting of the bones in Mr. Avery's burn pit. Clearly, the killer performed all of these tasks. Dr. DeHaan ruled out tires as the accelerant. Dr. Leisenberg claimed that she detected the odor of a flammable liquid and not burned rubber from the bones in the Dassey burn barrel, which the state claimed was the accelerant used by Mr. Avery. Mr. Avery was deprived of the opportunity to link the gravel pit bones accelerant to the Dassey burn barrel bones. The evidence against Bobby of motive and opportunity is apparent. According to Avery's brief, pages 49 through 65, 82 to 87, and 119 through 120. Additionally, if the gravel pit and Dassey burn barrel bones had been linked, the state's star witness would be converted into the primary suspect. Dr. DeHaan opines that the bones in Mr. Avery's burn pit were planted after being burned in a burn barrel. Dr. DeHaan stated, the discovery of larger fragments outside the margin of Avery's burn pit and the findings of human bone fragments with similar degree of fire damage in numerous other areas is also consistent with the dumping of burn barrel remains into the alleged burn pit, with some rolling or landing outside the pit. That's his affidavit, pages 615 through 695. If Mr. Avery establishes an evidentiary hearing that the primary burn site was the Dassey burn barrel and the bones from that barrel were planted in Mr. Avery's burn pit, that evidence would be potentially exculpatory and would undermine confidence in his verdict. Mr. Avery has established that the state acted in bad faith. Avery's brief, page 124. Bad faith can be shown by proof of an official animus or a conscious effort to suppress exculpatory evidence. See Jimerson versus Payne. Further, under certain circumstances, it is permissible to draw an adverse inference against the government when it destroys evidence. So I think what she's saying is that the mere fact that they destroyed the evidence is acting in bad faith. United States versus Davies. Vacated on other grounds, bad faith can also be inferred from the fact that the prosecutor deliberately misled the jury into believing there was no possibility of human bones in the quarry. 716 through 778. And that's exactly what Kratz, what we just talked about. Only 20 seconds, right, Millbilly?
Yep.
In Jimerson versus Payne, the Eighth Circuit held that the defendant established a Youngblood violation regarding a recording that was either lost or destroyed. The Eighth Circuit acknowledged, without the recording, we cannot ascertain its significance. However, the fact that it existed and the state failed to disclose it, demonstrated a conscious effort to suppress evidence. ID, the reasoning in Jimerson should be applied to Mr. Avery's case to find that in bad faith, the element has been satisfied because the prosecutor deliberately failed to preserve relevant evidence. And that would apply to the, seems to me like that would apply to the zipper or voicemail as well as the bones.
Mm-hmm.
But anyway, she doesn't argue that. She needed to listen to this podcast first. She should have gave us the draft, I think. What do you think? So that we could have gone over for her.
Yeah.
Yeah, exactly. Item 7. Because Mr. Avery's factual this is Roman numeral 7. Back to the main headings. Because Mr. Avery's factual allegations must be assumed as true, he is entitled to an evidentiary hearing. Mr. Avery's motion for relief was filed pursuant to Wisconsin Statute 97406, which requires a hearing unless the motion and files and records of the action conclusively show that the person is entitled to no relief. Wisconsin Statutes 97406, Section 3, Section C. The statute requires that the circuit court hold an evidentiary hearing when the movement states sufficient material facts that, if true, would entitle the defendant to relief, according to State versus Allen. In making this determination, the court must assume the facts alleged are true. Citing State versus Bentley, emphasis added. State versus Zealy, so she's citing 2 cases to support this. The facts must be true, and that's the State versus Bentley, State versus Zealy. And I think she has a quotation from one of these. Because the circuit court did not hold an evidentiary hearing in Zealy's motion, we will assume that the factual allegations in her motion are true. And that's citing that other case. Even if the facts assumed to be true seem questionable in their believability, the circuit court must hold a hearing. And that's according to in State versus Leitner, 2001, which stated that when credibility is an issue, it is best resolved by live testimony. Further, factual disputes may only be resolved at an evidentiary hearing, and that's State versus Hampton. The following chart illustrates the facts that must be assumed as true for Mr. Avery and the factual disputes raised by the state which necessitate an evidentiary hearing. So this table has 3 columns, so the topic, the fact, and the state's dispute. Okay, so if in Brady violations, and the topic is the Ramlow affidavit is the first one. Ramlow affidavit, RAV4 planted. The Ramlow affidavit is true. Mr. Ramlow saw the RAV4 on November 4, 2005, illustrating that, and that's at the turnaround near the Two Rivers Bridge, illustrating that it was planted. And the state's theory that the RAV4 never left the Avery salvage property is demonstrably false. Ramlow's affidavit impeaches Sergeant Colburn's testimony that he was not looking at the RAV4 when he made the dispatch call regarding the vehicle's license plate. Because the trial defense counsel did not have a police report documenting Sergeant Colburn's conversation with Mr. Ramlow, they could not impeach Sergeant Colburn. The chronology of the 30 tracks of the Manitowoc County Sheriff's Department calls to dispatch show that Sergeant Colburn's call was made on November 4th, 2005.
Yes. And there's only 79 dispatch calls for both lines for the entire duration from the 3rd to the 12th. And it's not even all days.
Wow.
It's only from like the 3rd to the 9th.
And how does that compare to Calumet, for example?
It's like no way in hell you can compare it.
Factor of 100 more. Like how many more? 100 times 100 times 1,000.
Every single audio file for Calumet is 19,038 files. Manitowoc is probably 300 if you include the transmissions, but just dispatch calls, 89. Just for one day, it's I don't know.
Yeah, it's a factor of 100 different, right? It's 2 orders of magnitude different.
It's been doctored.
Yeah, And they removed all the time and everything else.
Yeah, they're not time stamped,
Right?
but
So we don't have access to that.
I have been listening to the Calumet Dispatch and listening to the Manitowoc Dispatch and listening to what's happening in the background, because you can hear the radios from Calumet going off and you can pinpoint when things are happening. And there's only 79 calls, so it's not.
And when we put that time, yep. I can't wait till we have all that together. That's going to be great. When I say we, I think you have a mouse in your pocket.
Mm-hmm.
So the way that the state dispute Mr. Avery's facts was Ramlow seeing a similar car somewhere fails to establish any fact about the RAV4 being planted. Again, that sounds conclusory because that's what Zellner's saying, is that you have no choice but to assume the facts are true and hold an evidentiary hearing to determine whether or not Ramlow's correct or not. So the state's making a conclusion that even if it is
sightings of a RAV4,
multiple sightings,
not just Ramlow's. It just Ramlow's wasn't available to Stephen Avery during his trial. Had Making a Murder never came out, he probably never would have texted Scott.
Somebody's a guitar. Is it me?
Go ahead, Jeff.
Yeah, sorry. I hear the guitar noises and I get nervous that it's me. The kids are coming home. They're turning on Netflix. They're getting on their phone. They're going to bring the entire state of Massachusetts down the way that they download stuff. Continuing on with Ramlow, I guess I should have scrolled down lower. The photograph of the poster seen by Ramlow at the gas station included a photograph of Hallback's car. Okay. The state argues, assuming Ramlow's contentions are true, Ramlow never even knew what Miss Hallback's car actually looked like because he never saw a picture. Well, he says he saw a picture. I'd be interested to know, because Ryan Hilligus claims that his pretrial testimony that he didn't pick up the stuff from the Yes organization until Friday.
Yeah,
so,
but
one wonders how that poster got stuck up, right?
Dispatch call for the 3rd of November from Manitowoc. Officer Ryan Gilbert from the Manitowoc Police Department calls the Manitowoc Sheriff's Department because he just seen a missing persons flyer at that very gas station and wants to know if it's.
So who put it up?
My guess.
That's the question. Who put it up?
That's another thing.
He
failed to find out.
Yeah, I mean, he goes out of his way to correct Jerry Buting at his pretrial testimony and say, "Oh no, it was Friday. I picked that up from the Yes organization. Those posters, I picked those up on Friday, not on Thursday, on Friday." So if he picked them up on Friday, who put the one up at the gas station on Thursday for Ramlow to see? But anyway,
it'd be nice if we could see which one was actually at the gas station.
Yeah, it would be. Yeah. Hopefully one with a picture of the car that makes this true. So the next topic is Redon's affidavit that Zellner asserts that proves the RAV4 is planted. And so what she's extracting from the Redon affidavit is the Redon affidavit is true. The Department of Justice agents knew that the RAV4 was planted on the Avery property. And according to the state, I guess she's the next one to the right, and there's another one below that. So the state's response to the DOJ knowing that the RAV4 is planted is, Avery does not say who Redon had this conversation with, when it occurred, what the context was, what the person's belief was based on, or why Redon did not tell trial counsel or anyone else about it in the 12 years between trial and his affidavit. I mean, that's yet, it seems to me, yet another reason why you should have an evidentiary hearing to figure that out. Zellner goes on about that same affidavit that there's an issue, the following issue. Mr. Redon's affidavit contradicts the state's representation to the jury that the Avery property was inaccessible from the Redon pit. The state argues there was a 20-foot berm separating Avery's trailer from access to the rest of the salvage yard and Redon pit. So that's Redon's affidavit, and we knew that. You can see from the friggin' flyover video that there's more than one way into the salvage yard. I don't get that.
Wait, if you can,
Sure.
if I minimize this, this is the berm she's referring to.
Yep.
Goes all the way along the property.
Okay, her next topic has to do with the flyover video and the RAV4 being planted after 11/4. Her issue with it is the flyover video is deliberately edited to conceal that the RAV4 was not present on the Avery property on November 4, 2005. On November 4, 2005, Wendy Baldwin, who we'll call Ms. Baldwin as opposed to the cross burner, and Calumet County Sheriff Jerry Poggle conducted a flyover searching for the RAV4. They were in the air for around 4 hours and yet produced only 3 minutes of flyover footage. Prosecutor Kratz made a material admission when he told the jury that the RAV4 was not visible in the flyover video. Avery's brief, page 46. The state claims, the state's rebuttal to this argument was, Avery's claim that the flyover video was edited was utterly devoid of facts and relied wholly on Avery's speculation that more footage must have existed because the prosecutor said the RAV4 was not visible on the video and the flyover produced only 3 minutes of footage. Yeah, so I think there's an argument there. I mean, you know damn well why would they take so much video on the?
Yeah.
Yeah. Why would you take so much video on Saturday and take so little on Friday? They obviously deleted stuff either on purpose or by accident.
And don't forget.
And so Zellner's second.
Beginning of the flyover, you hear them telling them, "Oh, yeah, this is how you remove the timestamp," and they do.
Yeah, that's right. So Zellner closes her argument on that with a credibility determination must be made of the Kratz statement that the vehicle was not present. What did he mean by that? Shouldn't we have a hearing to figure out what the heck he meant by that?
And don't forget, Teresa's cousin, David Beach, was also let on the property and searched the yard. Talked to Stephen. Stephen gave him the same statement he always has.
Yeah, that was the 4th, right? That was the Friday.
Yes.
Yep. So Zellner's next issue, it's nice that she has this table laid out because I think even the Wisconsin judicial system will be able to follow it. Again, remember that Zellner's assertion as we go through these is that the various affidavits have to be assumed to be true by the various claims need to be assumed to be true by the court. And not conclusory. The state can't jump to the conclusion in their briefing that these arguments are irrelevant because they don't convince anybody. They have to be assumed to be true to have findings, have fact findings about them. So her next issue is the zipper answering machine. Miss Hallback killed after she left the Avery salvage yard. And her table, which is the facts assumed to be true part of it. The zipper voicemail was concealed because it demonstrated that Miss Hallback's final stop was the zippers and not the Averys. The contents of the zipper voicemail, this is in quotes, the contents of the zipper voicemail may have contradicted the timeline established by the state that Miss Hallback's last stop was the Avery salvage yard. Ms. Zipper, that's Jolene Zipper, I think she was short on words. Ms. Zipper testified at the trial that Miss Hallback arrived at their property at 3 p.m. The state placed Miss Hallback at the Avery property at approximately 2:30 p.m. The state's response to this was nothing about Hallback leaving a voicemail at 2:12 p.m. stating that she can't find the Zipper house, but then later arriving at 3 p.m. does anything to contradict the timeline established by the state, according to Avery's brief. So again, very interesting about that call. It's not on the AT&T bill. It's not on the singular wireless bill. So we don't know a lot about that call. Heidel's affidavit. Who's Heidel, no Billy? Can you remind us of that? Oh, we know she's the one who made the phone call, right?
Yes.
About the graduation pictures or something. Okay. Heidel's affidavit. Miss Hallback's day planner was on the RAV4 10/31/2005 and then in possession of Ryan Hilligus. Ryan Hilligus is established as a third-party Denny suspect because he was in possession of Ms. Halbach's day planner. According to the state, there's no proof that this was Ms. Halbach's day planner. I don't think that's what the state said, but that's what Kathleen is saying. I think the state said that there was no proof of how Ryan got it. Right? But anyway, still the same. That's probably a distinction without a difference. Here's a good one. The Vealy CD. Detective Vealy CD contained new material evidence that had been previously concealed from prior counsel. The forensic findings and opinions of Detective Vealy were entirely contained on the CD in his final report and not on the 7 DVDs. The CD contained recovered pornography, according to Hunt's affidavit. The 7 DVDs did not contain the results of Detective Vealy's unique search terms found exclusively on the CD. Those search results are as follows: 2,632 search results for the term blood. So one for the term blood, 2,083 for the term body, 3 for the term bondage, 10 for the word bullet, 23 for the term cement, 3 for DNA, 51 for fire, 50 for gas, 75 for gun, 2 for handcuffed, 106 for journal, 61 for MySpace, 54 for news, 74 for Rav, 32 stab, 2 throat, and 2 for tires. So that was a pretty exhaustive list of what was on the CD there. And the state's response to that, which they did not accept the truth of the allegation, Avery does not point to items of evidence he did not have that were on the Vealy CD, but not the hard drive. In other words, they're saying, that having the CDs was the same as having the hard drive. He just complains that he could not have guessed what the search terms Vealy used during his examination. We went over that. And, I still contend that the state's argument is that Vealy, not having the report is, or giving the report is like saying, here's the dictionary, all the words from the report I'm going to write you is in the dictionary. You just have to figure out which ones are in there. And when we're talking about a unique work product, I believe that the defense is entitled to it. But I think we went over that the last time. The next, impeachment of Bobby Dassey's trial testimony. And she has a footnote here. I'm going to read the footnote to see what that says. So that's down at the bottom of the page. Wisconsin statute 904.04 provides that evidence of other crimes and or wrongs / acts when offered as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident is admissible. The court in Dressler versus McCautry held that the acts admitted pursuant to this section were the defendant's possession of pornographic videotapes and pictures. So there's something that says that possession of this kind of stuff is sufficient to prove at least motive or frame of mind, or basically that he was in a horn dog kind of mood. Let's put it that way. We know there was deletion. We know he was on the computer that morning because there were entries. We know there were deletions of items on the computer that even Vealy couldn't get. But anyway, Zellner continues for her side. Bobby committed perjury at Mr. Avery's trial when he testified that he never saw Ms. Halbach leave the Avery property. And the state's rebuttal to that, and she has that from the affidavit of Brian, right? Who said that Bobby told that. That's what Bobby said to him, that he never saw Halbach, that he saw Halbach leave. Avery fails to explain why a single statement from Brian to the police that Bobby saw Halbach leave the property would have tipped the scales when the wealth of other evidence pointed at Avery, and when the jury already heard multiple other accounts that conflicted with Bobby Dassey's testimony. So again, that's just not admitting the truth. That's again seems to me to be conclusatory that people would have concluded otherwise. Mm-hmm. Again, a second argument related to the CD is that this CD contained exculpatory material evidence that was directly relevant to the credibility of Bobby and would have allowed trial defense counsel to allege Bobby committed the crime, and the state's failure to disclose it violated Mr. Avery's due process rights to a fair trial. Only Bobby had access to the computer during the day on the weekdays when the violent pornography searches were conducted. Okay, so I think there's more. Bobby's trial testimony that he was asleep from 6:30 a.m. to 2:30 p.m. was contradicted by current post-conviction counsel's expert, Mr. Hunt, who found that Bobby accessed the computer 6 times during that time frame. Now, that's at least because we know there's some deletions as well. The state's response is, the fact that someone views violent pornography does not diminish their credibility as a witness, as Avery claims. Although distasteful, it has nothing to do with their truthfulness, nor would viewing violent pornography refute anything about Bobby's claim that he never saw Miss Hallback leave the Avery property. And fundamentally different arguments. The state didn't really refute Zellner's argument there, in my mind, that Bobby's testimony could have been completely refuted and that he really should have been looked at as a suspect, not as a reliable witness. And that really turned some heads in the trial when he pointed over at Stephen. Again, a new subheading in this title, which is factual disputes regarding the ineffective assistance of counsel claims. And again, we're going to go to the issue, Zellner's saying, and the state's response. So the factual disputes, according to blood spatter expert Stuart James, Zellner's point is, the blood spatter in the RAV4 was selectively planted and did not come from an actively bleeding finger, right? You don't bleed blood flakes, last time I checked. And the state responds, but Stuart James' experiments simply assume a number of variables James cannot account for, such as how deep Avery's reopened cut was, how much a partially healed cut would have bled, how he moved about the RAV4, and the many other ways blood flakes could end up somewhere. Again, it seems like, to me, yeah, there's a factual dispute, but should we just dismiss it, or should we have an evidentiary hearing to figure out about it? The bullet fragment item FL. Her issue was bullet fragment item FL never passed through Ms. Hallback's skull, as the state's experts opined. Forensic pathologist Dr. Jensen testified that Ms. Hallback's cause of death was a result of 1 or 2 gunshot wounds to the head. Dr. Jensen testified that Ms. Hallback's DNA got on item FL, but it traveled through her brain, causing her death. And she quotes "through her brain." I guess even though Sweaty Boy says, "Well, I never said it passed through her skull," it seems to me like that Zellner's got the state on the hook because their forensic evidence said it got on FL when it traveled through her brain, causing her death. Wow, that's a bombshell to me, because that totally disputes what the state and what fat ass Kratz said. Dr. Leisenberg testified that there was no evidence of other gunshot wounds to the bones from other parts of Miss Hallback's body. The state's side of this argument, according to Zellner, but contrary to what Avery claims, no one, what about Dr. Jensen? No one ever said that FK and FL were the 2 bullets fired into Miss Hallback's skull. Avery made that inferential leap on his own. See Avery's brief, several references. The next one, and we have to follow Travis's guidance here, that she starts with a good one and then inserts probably bad ones and saves the good ones for the end. So this, under this heading, this is the second one. The groin swab is planted. This groin swab one is her shot at Wiegert Fassbender, in my mind. Her argument is the groin swab was substituted for the hood latch swab by Investigator Wiegert. Investigator Wiegert had handprinted Deputy Hawkins' name on the form, again deliberately identifying Deputy Hawkins as a bidding officer, which was a complete misrepresentation. The state fails to acknowledge the significance of Investigator Wiegert signing Deputy Hawkins' name on the Wisconsin State Crime Lab form when he delivered the alleged hood latch swab. The state's argument is Avery based this scenario entirely on the failure of the nurse to note her report that a groin swab had been taken but discarded, which according to him, a well-qualified nurse would have done. And the fact that Wiegert and Fassbender instructed Deputy Hawkins and Sergeant Tyson to swab the hood latch battery cables and interior and exterior handles, but did not include the interior hood release lever and hood prop. So yeah, there's definitely a factual dispute there. The Hillegas evidence. Next topic. Trial defense counsel was ineffective in failing to investigate Hillegas as a third-party Denny suspect. I don't know how you can disagree with that. But the state's argument against that was Avery provided nothing establishing one, the abusive relationship Hallback supposedly was in with Hillegas. We know about the fight at the Halloween party in Green Bay. Compare 603:123 with 615:288. Item 2, that Hillegas knew about Hallback's sexual history with Blodorn. And 3, even if Hillegas did know about it, that he cared. Okay. Also, 603:123, Avery just proclaimed with no evidence whatsoever that Hillegas committed perjury about it. There's okay, and that's the end of that one. More evidence regarding Ryan Hillegas is she says it must be assumed that Hillegas was in possession of Miss Hallback's day planner, according to Avery's brief 48 and 49. The state says there's no proof that this was Miss Hallback's day planner. Well, I think that there is proof because of the affidavit that says that there was writing on it, and there's actually 2 affidavits that she got. One was from Heidel, and the other one was from the Steve and Sheboygan that she made before the Appleton stop or the new Holstein stop, and the Steve and Sheboygan's name is on there, and he also said she pulled over to make some notes on the thing. So not sure why she didn't reference that one. Sub-key planted location. The bookcase experiment, the Remember Zellner's famous Sergeant the Colburn challenge. Sub-key planted location. Bookcase experiment demonstrates that the state's trial theory about the discovery of Miss Hallback's key in Mr. Avery's bedroom was false. How could it possibly fall out and end up where it did? Importantly, experiment key and lanyard were able to be pushed back through the back of his experimental bookcase by striking it with a photo album. State's brief 38. Again, factual disputes there that really just need to be resolved by a evidentiary to the jury, even if you believe the key's planted. It's so unbelievable that the key was found when it is. The sub-key was planted in Mr. Avery's bedroom as evidenced by the bookcase experiment and the DNA quantities. Dr. Reich opines that the DNA found on the Toyota sub-key found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA on the exemplar sub-key than that was discovered at the Wisconsin State Crime Lab and used to convince Mr. Avery. The state disagrees and states in their brief, what Avery glossed over was that he undeniably left his DNA on the exemplar key during the experiment, which again, obviously conducted in a controlled environment and cannot account for the many other variables that could lead to Avery depositing more skin cells on the key, and with Avery in a different physical condition, sweaty, than one would be when trying to hide evidence of a murder. So again, dispute. Me personally, the key is one of those things where you say, if they planted one thing, everything it's got to be in question. Significance of the sub-key. In Zellner states, Dr. Reich opines that the DNA found on the Toyota sub-key found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA in the exemplar sub-key than what was discovered by the Wisconsin State Crime Lab used to convince Mr. Avery. So again, this is the same argument, but it's the amount in question that shows that that was probably planted. The state comes back and says, second, like his hoodlash experiment, Avery's experiment holding the exemplar key bolsters rather than weakens the state's case. Oh yeah, clearly another difference. Next issue is electronic devices planted. Current post-conviction counsel's investigator conducted a series of experiments refuting Mr. Fabian's trial testimony that on October 31st, 2005, he was in the vicinity of Mr. Avery's burn barrel and smelled a distinct odor of burning plastic coming from Mr. Avery's burn barrel. mean, Steven said he hadn't burned anything in weeks.
Yeah. The last person
Avery's experiment could not account for environmental conditions on October.
Go ahead.
What's so, Jody?
Yep.
Avery's experiment could not account for environmental conditions on October 31st, 2005, any sensitivities of Mr. Fabian's, or the fact that Avery clearly put other items in the burn barrel as well. So again, factual dispute worth investigating at a evidentiary hearing. Now on to the Youngblood violations. These are some of the best ones. Destruction of the bones. Zellner argues the circuit court erred in concluding that the Manitowoc County gravel pit bones were non-human, when in fact the Manitowoc County quarry bones were labeled as human by Dr. Eisenberg in her reports describing property tag numbers 7411. Calcined human bone fragments. Item number 7412, human and non-human bones. 5 of 13 calcined bones with cut edges. Most bone fragments are all cut. Bone fragments are human. Number 7413, one burned human fragment. Number 7414, burned calcined human bone fragments. Item number 7416, human bone fragments. Human is calcined with one cut edge, and 7419, cut/burned human bones. But the state says none of the bone fragments recovered from the locations of the quarry were positively identified as human, let alone the remains of Theresa Hallback. And again, the cut marks is something that I hadn't even thought of before until I read this brief right now. But yeah, definitely a difference in facts. Yep. So the Brady violation leading to the Youngblood violation, one of her issues, it must be assumed that there was a Brady violation when the state failed to disclose the police report. The failure to disclose the police report led to the destruction of the gravel pit bones, of which prior post-conviction counsel was unaware. So she's talking about the last page of the report. There must be an evidentiary hearing to determine whether prior post-conviction counsel knew of the specific bone fragments that were given to the Hallback family. And the state argued that the state conceded that there would have been a Brady violation if prior post-conviction counsel did not know about the evidence that was destroyed. So on to the conclusion. I can't believe we're at the end already. This to me was like a good game of whack-a-mole, where every time the state popped its little head up, Kathleen took her giant Donkey Kong Mario hammer and pounded the state down. Very short conclusion here, and then we can get on to Travis, because I'm very anxious to know his timeline. For the reasons stated herein, Stephen Avery respectfully requests that this court grant him one of the following alternative remedies. 1, reverse the orders denying post-conviction relief and remand for the state to file a response to the motion for post-conviction relief and order additional scientific testing per the September 18, 2017 agreement, and or grant an evidentiary hearing. Or 2, reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. Dates this 25th day of June, 2020, respectfully submitted Kathleen Zellner, Stephen Richards, and then there's this certificate of compliance, which I don't think anybody's interested in. And she did e-file it, according to, and then certificate of form and the length. I don't think anybody cares about that either. But okay, I mean, with that, I'm going to hand it to Travis. There must be 1,000 comments in the thing, so let Travis do his thing, maybe, and address the comments in the chat.
Hey, Travis,
I'm going.
the first question was, I believe I go back. One of the questions was in regard to Judge Suckowitz. And I think you've answered this before, but they're asking if she's going to ultimately end up being the one, if there is an evidentiary hearing, to have it presented in front of her, or what can they do for that not to happen?
If it gets remanded for an evidentiary hearing on one or more issues, I think it's generally agreed that it gets fully remanded back to the circuit court, and under their procedure, she's entitled to file a motion to recuse, which is automatic. She's filed that twice before, but it's been denied because the case has already gone up to the Court of Appeals. And she didn't file that until it went up on appeal. But it was acknowledged that under their procedure, if it is remanded fully back to the circuit court for an evidentiary hearing, she'd be able to file that motion to recuse. The court could even rule, the appellate court could even rule that, well, they could do it a couple of things, but they could rule that it should go back to a judge in Manitowoc County. But baby steps, step by step. First, we need to get an evidentiary hearing, and then likely it will be heard by a different judge, hopefully anyway.
So I want to have you answer. I had asked you beforehand, were you surprised about any of this? What is your opinion on how well KZ responded? And do you think that it's going to have the effect that she intended with her response?
Well, to answer the second part, who the hell knows? It's got to get in front of the judges, and they're going to make their decision. Her intent is to get either an evidentiary hearing on one or more issues, or
a new trial,
and that's her intent. I'll go back to what I said. There's no way to predict on this stuff. Despite what people think on both sides, these issues are not clear cut. And I can guarantee you, in a private conversation with KZ that she knew wasn't public, she would admit that the last thing on earth is that she wants to have an appeal that's in a procedural posture where the state has the ability to make the argument of procedural bar. You just don't want to be in that position. Having said that, she anticipated it. She set the state up. They spent all of their time on procedural bar, the good portion of their brief, and she comes back with this fantastic, brilliant argument of estoppel. And, let's just replace the word estoppel with fairness, fundamental fairness. And, that is just brilliant. But there's no case like Youngblood that says, hey, when you agree to do testing at this stage, there's no case that says that. There's no rule that, nothing. But she's got an argument that fundamental fairness requires you ignore this procedural bar stuff, that you don't let a litigant, whether it's the state or anybody else, get away with setting up a plan that favors the judicial resources, litigants working out things like testing and issues and abandoning issues and amending things. That does nothing but good for the court system. That's why litigants do it, whether it's, and you heard in MAM 2, Zellner said, yeah, we're working out items to be tested, and we've worked, and she's in her car driving, talking about it. She explains that it's always better if you can come to an agreement. It's quicker, it's much more streamlined. You have to pick your battles. And so they were doing that. And I get the impression that Zellner respects Fallon and that they were working together at the time. They had gotten that bullet tested, that Fallon was representing the interests of his client, the state of Wisconsin, she hers, but there was mutual respect and that they were working together on these things. And there's no doubt in my mind that the documentarians were in her office. That wasn't restaged. You know, a lot of stuff like Housewives of New Jersey and whatnot. You can tell it really happened at one point, but they try to recreate it because the cameras weren't there. There's no doubt in my mind those cameras were there when that thing came down, and the judge granted that motion out of the blue, and that they called and were on that speakerphone live, and then you notice they cut it out. She was in a conference room, which that's what a ethical, respectful lawyer would do, is say, hey, look, you know, I'm sorry, but y'all are going to have to step out, and I need to talk to these attorneys on the other side. And then it cuts to her talking to her partner saying, well, they won't join the motion, but they won't oppose it, which, you know, that's pretty big. And so this goes all the way back to October of 2017 when that order came out and she filed a motion for reconsideration when she knew that they weren't going to oppose. Part of being a great appellate attorney is by what you put in these motions and at the trial court level, the circuit court level. So just think if she hadn't have been so thorough in her affidavit to say, you know, we had agreed to this, more testing and these specific items, and we had agreed to evidentiary hearing at the beginning of the year, and we had agreed it was this many days, and you have those kind of specifics, you know that that's true and accurate. So the big surprise, I thought she was going to come back blasting, but I'm really glad to see this judicial estoppel fundamental fairness argument, because hopefully that will relate to people in Wisconsin and around the country that are of whatever their opinion is on the guilt or innocence, that it's questionable whether he got a full and fair trial, and that fundamental fairness allows, and that's what her chart is brilliant at. She's pointing out to the court, your job at this stage, or the circuit court's job at this stage, wasn't to decide who's right. It was to decide, is there enough of a factual basis, an underpinning, to allow an evidentiary hearing to find out who is right or wrong. These people will, you know, come in and say what they're going to say, and it's up to the court to determine, well, yeah, you know, I'm sorry, I don't believe this person. And you all are familiar with other actual innocence cases, and where the victim comes in and recants, and court just says, you know, sorry, but people come in and recant for all kinds of reasons, not good enough. People, what the hell, you know? But and so, but you know, they have an evidentiary hearing. The victim comes in. Okay, you testified under oath that this was the perpetrator, and Now you're saying, it's not. And prosecutors do this to victims. Well, were you lying in court, or, you lying now? Like, no, I'm just mistaken. The police told me it was this person. And, you all have seen the series. What's the name of that series that's out recently? It's
The Innocence Project one.
yeah. And my good friend Patricia Cummings, who's from Central Texas, is the head of the Philadelphia Conviction Integrity Unit. And at that phase, she had worked hard, and they had righted a couple of wrongs. What most people don't know is since that series, they're getting major pushback from the police department. She has 3 more cases that she got everybody to agree to deserve to be turned over. And the circuit court, the trial court there, said, I don't care. I don't care what y'all have agreed to. We're not doing it. It's now to the point where it's political. That mayor from a completely different side of the fence came in, was going to drain the swamp, clean house, whatever you want to call it. But the police union's up in arms. And so, it's you got to have some fundamental fairness in the thing to tip these cases. And I think she's done it in that Roman numeral 1 right off the bat. Hey, we all had a deal. We were all working together. And just because they're in a different office up in an ivory tower someplace in Madison, Wisconsin, they shouldn't be allowed to, get around the deal that was struck by the attorneys working in the trenches. And so that's a pleasant surprise. It's a long answer to a simple question, but I think there's a lot to be enthusiastic about on that.
Yeah, there are no simple answers in this case, that's for sure.
So how long do you think this is going to take to play out?
Okay, so I did some research when you contacted me early afternoon, because I knew this was going to come up.
Is he getting the bill for that, by the way? We have his address. You need to send him a bill.
By the hour, Travis, by the hour.
He just has to buy all the drinks. Get out there. So the JJ on the first page, that's your Old English. Actually, that's capital I for the 2nd district. There are 4 district appellate courts in Wisconsin, and we're in District 2, which is essentially all of southeast Wisconsin, bottom right-hand corner, except for Milwaukee, which is the 1st district, which is kind of a donut in the middle. And there are 4 judges in each district. So in District 2, which covers both Calumet and Manitowoc, and also, what's the county where Judge Flowers is all the way down south?
Sheboygan.
Where's, what county is that?
That's south of Manitowoc.
Okay. Right next to it, or is it south part of the state?
Below it.
Deer?
Where, yeah, Angie is.
Yeah, Sheboygan. Okay.
All right. Where is that? That's the county just south of Manitowoc? Okay. Yep. All right. So our 4 judges are Neubauer. Might remember her because she ran for Supreme Court and lost. But she won her reelection for Court of Appeals. Governor Evers appointed her to be the chief judge of the entire appellate court system. Judge Riley Judge Gundrum, and you all may remember that name. He's the legislator that was working with Stephen on the Stephen Avery Act. We suspect that he will probably recuse himself because of the work he did with Stephen. It would constitute an appearance of impropriety. And then Judge Davis, who was appointed by Governor Evers. So it'll probably be Neubauer, Riley, and Davis. Zellner requested oral argument in the case. The state, as we will recall, said, oh, it doesn't involve anything important, doesn't merit an oral argument. Oral arguments are rarely granted at the Court of Appeals level in Wisconsin on any type of case, especially a criminal appeal. There were, for example, last year, there were a total in the Second Circuit 4 oral arguments scheduled. Those were all civil cases, and there were 3, all civil cases. One was about the expungement of records. It's kind of criminal. You get arrested and they don't file charges on you. It's hard to really predict anything. Gundrum had a weird opinion in one of them. So I think it's going to be good if Stephen didn't have him anyway. So there were two cases where the oral argument, the last one is a case called Hall. They've submitted all their briefs, like what happened today. The reply got filed on August 15th of 2019. Oral argument, and remember, this is all pre-pandemic, which throws a wrench in things. Oral argument was scheduled for December 17th of 2019, so 4 months later, and an opinion came out February 26th of 2020, 2 months later. There was a case this year without oral argument, pre-pandemic. The reply was submitted on January 9th of 2020. And again, these are 3-judge decisions. Stephen's case will be a 3-judge panel. In Wisconsin, if it's a misdemeanor or traffic citation or other minimal type offenses, 1 judge can decide it. That's not going to be the situation here. Ours will be a 3-judge panel. Obviously, if you have 3 judges, it takes longer to confer and so on. So I just used 3-judge panels. There was a case, a reply was submitted January 9th, and the decision came out April 15th, so 3 months later. Right now, pending this year, it's been rescheduled once because of COVID, and they don't have a new date yet. It was set in March. They kind of moved it around to April, but they have set a criminal case for oral argument in the Second Circuit. And so while it is true that they never, ever, ever usually set criminal cases for oral argument at the Court of Appeals level, again, this isn't the Wisconsin Supreme Court, there is one that is waiting to be scheduled right now for oral argument. So if the court is going to grant oral argument, which is rare, we would expect that to probably be scheduled 3 to 4 months from now. And then a decision 2 months or so after the oral argument. If they don't grant the oral argument, we should expect a decision 2 to 3 months from now. So that's not bad.
Wow.
That's way quicker than
That's
3 to 6 months, depending.
I thought.
And despite COVID, they are the second court. I pulled up all the cases that have been cited out of the second district court of appeals for the last 12 months. And they are deciding between 3 and 5 cases a month. They issue opinions. And so they're obviously continuing to work from home or wherever they're working, and they're conferring however they're conferring. They have set up, like the courts in Texas, oral arguments by Zoom when they do have oral arguments, and anybody can watch them. And so I will continue to monitor that criminal case, and as soon as that's scheduled, I'll let Millbilly know so he can put that out, and the other things that I'm on, let y'all know, and
Definitely.
we'll be able to watch that. But that's going to be historic in and of itself. So.
Well,
What other questions we got? The name of that case, by the way, if somebody else wants to look it up, is State versus Manuel Garcia. It's a 2018 AP, which is how they do all their appeal cases. AP 2319-CR. 2018 A like Apple, P like Paul, 2319-CR. State versus Manuel Garcia was set for an oral argument, canceled, and their docket shows waiting to be rescheduled. And I think that's a good one. I don't know what the issues are. I didn't have a chance to look at any of it, but never had another criminal case in the second district to track or compare. So that's fortunate we're able to look at that.
all right. Well, I thank you for your insight. I thank you, Jeff, for reading this. Thank you all for joining
Thanks, guys.
Yeah, that was great, Jeff.
Awesome, guys.
So if when I get fired from my job, can I come down to your law offices and maybe have a job for me emptying the waste baskets or something?
Yeah, I'll just write the stuff and then, put a screen, and then I'll just have you read it. I'll be sitting at the ranch, and if something comes up, a question, just call me. But yeah, I'm just gonna have you read it.
All right. There you go, Jeff. Thank you again.
Man, I'll tell you what, that's not what I was hoping.
Hey, thanks,
There must be a
Billy,
zillion
for
questions.
jumping on this and putting aside the time. You had a really good turnout, really good comments throughout, and I know it's like shifting gears. It's shifting gears between. You were discussing some of the things you had found. Just create more questions or.
Oh, yeah. Well, definitely when she gets a new trial or evidentiary hearing, they're screwed. New trial, they're screwed. All this info that we have now that Dean and Jerry didn't have.
Right.
Just that one phone call alone about them finding bones 2.5 miles away.
Yep.
Right.
So let me ask one quick question for you all. So is it scary that Zellner has to go to the trouble to put a side-by-side chart to make it that clear that, look, that what the state argues creates more factual questions than it answers? And Normally we don't need to put a chart, but I noticed that she's been using charts with this.
Proof it.
It's all about presentation.
Well, I think when you have corruption to the level that you do in Wisconsin, and whereas Judge Asshat is really just a stooge for the state here, who's just propagating. Who if she could keep Avery in jail for the rest of his life and not have anybody hear another second on it, she would definitely do that, because she's in the tank for Kratz and the rest of the state. When you have that level of corruption and that level of judicial bias, things like this end up happening. So she's incapable of making a decision. Her judgments are poor. She's constantly papered, as you said, which I think that means overturned. It's not surprising to me. I wish there was a path for an honest judicial review and an honest evidentiary hearing once we got once this is remanded properly to a lower court for the evidentiary hearing. But I have my doubts. Before you go, where do you think your next appearance is going to be, Travis? I mean, you're the most highly sought after guest in the MAM community now, you and Tracy. So where are you going to be next to give people a clue?
Well, Tracy is taking a well-deserved vacation, and I don't. Actually, I got somebody got a bunch of records, or is waiting any day now to get some FOIA records.
That you're going to be back here.
And I don't know how, but anyway, they asked, when they come in, can I help explain? So that's going to be my next thing. I don't know if they need me to explain beforehand, behind the scenes, which is fine, or be around to explain in this format. But of course, I'm happy to do either.
They'll be coming in this next week. The mail system is slow with COVID and everything, but definitely we'd like to have you come back and go over everything with us and give us your input and sit around with the rest of the gang.
Yep.
Yeah, because this stuff sometimes it seems maybe to point in one direction, and then it turns out, well, no, this is a common thing. One example has been like the lawsuits that the homeowners insurance company has filed to disclaim coverage. That happens in every 1983 case I've ever been involved in. But then there are some things that just don't make a lot of sense, and you have to dig in, and they may or may not be explained. A lot of the stuff that Millbillies looked into, that Jeff's looked into on phones and pinging and text data and things, there either wasn't enough information because it wasn't looked at, or it wasn't obtained. And then other things don't really need a lawyer. It's people are going to look at it and they're going to come to their own conclusions, which are fine. That I think there's evidence that there's a distinct possibility or probability that maybe there was another vehicle involved that was planted, or I think there's a distinct possibility that groin swabs were substituted for keychain swabs. We all have our opinion and whatnot, but the point I'm trying to make is, in this legal context, it's a finite sphere that's limited by what's in the appellate record. So you saw in this reply that she references, because you're only allowed to respond to what the state says in their response. She references constantly what page in the brief, they're yapping about this, and then that gives her the right to respond. And you saw in her brief and the state's response, they're constantly citing to the appellate record, because if there's not something in the record that says there's more than one RAV4, she can't argue it. Or likewise with the state. But people, why isn't she arguing this? Why isn't she arguing that? It's just, you can't have the full dialogue that you all typically are able to have in your own review and analysis of the documents. But I'm more than happy when they come in, whatever legal context or perspective I can give. Y'all know I'm more than happy to do that. But keep doing what you all are doing.
Thank you for your time on that.
Thank you. And y'all have a good night.
Good night.
Good night, all.
Bye.
Thanks, Travis.